Art Howard will call the Collection Service Board meeting to order. August the 8th, 2018. Glenn, would you?
Yes, sir. I'd be glad to. A notice of August 8, 2018 meeting of the Collection Service Board meeting was posted to the Collection Service Board website on August 1st, 2018. Chairman, would you like me to take roll?
Sure.
Well, I'll just run down the roll right quick. Bart Howard.
Here.
Steve Harb.
Here.
Josh Holden.
Here.
Chip Hellman. And then Angela Hoover. You have quorum.
Here.
Thank you very much. You have quorum.
Thank you, sir. Josh had me busy over here, wondering about my ride getting here on time.
While you're looking for your agenda, we'll just quickly go while you're getting your documents in order there. The first document is the agenda. Is there any questions about that, or will we approve that agenda? Does anyone make any motions or any edits?
So moved to
All right.
approve.
Sounds good. We got a second?
Second.
All in favor?
Aye.
All right, sounds good. We'll just work our way down the agenda then. The April minutes, anybody have any questions about that or anything that needs to be adjusted or edited or added?
Fine.
Okay, if we can have a motion in that regard.
So moved.
Thank you, Ms. Hoover. Do we have a second?
Second.
All right, we have a second. All in favor?
Aye.
Thank you. We'll move on down to the director's report. There's only, I believe, one actionable piece in the director's report. That'll be the meeting dates, but we'll just start there then. If you want to take a look at that. I'm going to pull out your calendars and let me know if those will work for you next year. It'll be document number 4.
Was our next meeting the February, or do we have?
Oh no, that'll be for next year. Our next meeting will still be October the 10th, I believe, is when that is for this year, and we may even have I think 2 more this year. If you've noticed, we have reduced them down to quarterly meetings. We just find that now that based on some of the prongs, and we'll talk about the complaints process as well. But based on those prongs, we're seeing a reduction, and you'll see that in the budget. So I look forward to talking about the budget. We are seeing an immediate impact on a reduction in legal costs, and so we don't need to have a meeting every other month like we were before. So if this works for your calendars, and we tried to pick meetings that were, I believe it was the second Wednesday of those months. That's typically been our pattern. So
We have it for December the 12th and then October the 10th. Those are the rest of this year.
sir, that's correct. And then for next year's schedule will be February 13th, May 8th, August 14th, and November 13th. That work for everyone? Okay. If we can have a motion in that regard.
So moved.
Thank you, Ms. Hoover. Do we have a second?
Second.
All right. Thank you, Mr. Harb. Do we have and all those in favor, please say.
Aye.
Thank you very much. Those are approved. Okay, we'll move on to the budget, and this will just be pretty much informational purposes. At the last meeting in February, you'll recall we introduced 3 prongs to address rising legal costs due to complaints. Those were complaints outside jurisdiction, withdrawals, and the possible use of an agreed citation schedule, which we'll talk about towards the end of our agenda. Complaints outside board jurisdiction, we determined will still continue to be closed per SOP, Standard Operating Procedure. Those complaints adequately withdrawn by the complainant will no longer be referred to the Legal Division for review. And we discussed that as well, if you recall. I made a motion in that regard. So if you'll note on the budget, please note the dramatic reduction in legal costs since instituting the first 2 prongs. You'll see right there, and of course the highlighting actually didn't comport, but you'll see you have 9,000 beginning of the year, 7,000 legal cost backs, and then you get back to 4,000 in February where we made that decision, and then right after that 2,000, 3,000, and 1,000. So dramatic reduction in legal costs, and it was a result of instituting those reforms. And we could, one of the discussions we're going to do is we can even do more potentially with an agreed citation schedule. And obviously we're handling these in a timely manner since they're not all being referred, and so hence the quarterly meeting schedule as well. Is there any questions on that particular piece?
Just out of curiosity, these are attorneys that are working for the state.
Yes, sir, that's
We're not
correct.
hiring them to be done, but
That's correct.
you bill their hours to a particular department or
That's correct.
regulatory board.
That's right.
And what do those lawyers do when they're not doing this?
They're working other cases. You have disciplinary action. Like for example, Dennis over here, Gregory, he works other boards as well. So when he's not working collection service board, he's working other boards. He's not full-time collection service board. Just a billable hour that he's working for collection service board is when that would be appropriated. Anything beyond that would be appropriated to those boards.
Thank you.
Yes, sir. Also, as a result of that, we've had a little bit more where we weren't, tracking in the red as much those last 4 months, as you can see. And the one time we did go in the red was a dip into it. So right now, if we can, we'll move to the next page. Remember, so right now for this fiscal year, we're tracking about 11,000 net deficit. But if you look at the second page, the very bottom right-hand corner, if you see the highlighted there, we have a reserves of $663,000, which, if you recall as well, at the February meeting, Chairman Howard, he gave us a report from the sunset hearing, meaning they wanted to dip into those reserves. So, 11,000 is not a bad start, but I mean, obviously we don't want to continue, for it indefinitely. But you can see we've kind of plugged the hole with the complaint schedule. So we feel really good that incrementally we can do it over time and then make whatever adjustments we need to. So we're taking action on both fronts. So it's going where it needs to go.
Yep.
All right, and then the last page.
Question for you.
Yes, sir.
What other reasons do we use the reserve?
That's about it. I mean, it's not like if you were to, you can. Any sort of cost dips into those reserves. So whatever deficits we run in the fiscal year. So all of those line item budget items. For example, on the third page here, those are Edison expenditures. And if you look at those, just typical business expenditures, if they exceed the course of operation expenses for the fiscal year, then that's how we get into the reserves. Eventually, some boards have looked at lowering their licensing revenue. We haven't done that yet because we've got a lot of folks that are taking advantage of the exemptions. And so we have a lot of folks that aren't renewing those licenses. And so as a result, license revenues are already taking a dip. That's why we're starting to see a decline in those revenues. But at the same time, too, now that we're plugging the cost, now we're just seeing a slow reduction in the reserves, which is what we want. It's controlled. So that's where we're at so far. Anybody had any questions about the budget?
How did we get the reserve?
Just
The obvious way?
Each fiscal year building. If you look on the second page, for example, operating costs as they accrue each over the year. You look at the fiscal year 13-14, you had 272, and then you add to that each year based on your operating costs. If you got net surpluses, that's how you end up with your reserves. So it's not like there's some sort of like revenue drive or anything like that, or anything quarterly. Like you have some, for example, in probation and private probation, they pay provider quarterly fees, and so every quarter when those hit, you see a dramatic spike in revenue. The Collection Service Board doesn't have anything like that. They're not in the same renewal cycle. Like for example, land surveyors, they're all in the same renewal cycle. So every even year, you see this huge spike in revenue, but then a dramatic reduction, or net. You see for the following year, you'll see net deficits, but they always balance out and they end up adding to the reserves typically. I mean, you don't want to always. We're not in the process. We're not in the business of, saving money and building reserves. I mean, that's why we have sunset hearings. But part of the sunset hearing is they're looking at is sufficiency, self-sufficiency, and that's on typically a 2-year cycle. Primarily because you have land surveyors that are on a 2-year cycle, or other boards that do that, but they just want to look at the overall health of the board. And here, with us going in a net deficit for one year of $11,000, when they're trying to reduce the reserves anyway, that are sitting at 663, with the exemptions, seeing less renewals, we feel like it's at a good place. That was just for your edification, but there's nothing actionable on that. If we may, then I think let's see. I want to make sure I've hit everything. I think so. Yeah, okay, we're good. I think we're able to move to the legal portion of our agenda. looks like we're up for the legal report.
All right, starting with Dennis Gregory for the agency. Number one, 2018-008891. Recommendation,
Oh, so just the, I think just
just
enough
the
for the
number.
record. Right.
Okay. Number two, 2018-009181. 2018-01-0751, 2018-01-1991, 2018-01-2371, number six, 2018-01-4061, seven nine one one, seven 2018-02-0031, 12 2018-02-1311, two thousand 02-1551, eighteen 2018-02-7641, twenty 2017-07-2971, and number 21 2016-04-3131.
Comments? Anyone from the board?
On individual,
Yes.
on number 2, which is 9181. It's an out-of-state agency that's licensed in Tennessee and is not responding. And we're letter of warning.
Well, we actually can't, for an out-of-state licensee, we can't impose the failure to respond. If it's a Tennessee licensee, we can. So if it's an out-of-state licensee,
Why can't we?
Doesn't
well,
our licensing require them to respond?
if they are a Tennessee licensee, this is an out-of-state licensee.
They have a Tennessee license.
No.
Then they're collecting in Tennessee without a Tennessee license?
Correct. That's what the issue. That's why the complaint was filed.
But they can't do that.
Correct.
I mean, they have to. So that was the complaint.
But we're only giving a letter of warning for failure of licensee to respond to a sworn complaint. We're not giving them any kind of penalty for trying to
Well-
collect in the state from being unlicensed to collecting in our state.
Let me make sure I've got the right.
Yeah. Got a bad attitude towards not charging them enough if they're out of state collecting in our state.
I think number one is the same question in my mind.
I agree.
So, correction on 1 and 2, they are both licensees
Tennessee.
in Tennessee.
They have an office in the state.
They just-
Correct. Or they have a Tennessee license.
So it doesn't matter whether they're in New York or Tennessee.
Right.
Right, they all treated the same.
That's right.
I kind of see Steve's point and sort of agree with him, sending a letter of warning to a non-licensed agency or an agency that refuses to respond. Us that are licensed agencies go through a lot of hoops and jump through barrels and everything else in order to be licensed and keep a good license and keep a good rapport with the state. And then we just give a letter of warning to somebody that doesn't comply with our rules, even though he has licensed and he should know the rules.
Right.
I think if he has a license, he ought to be more diligent and respond. Otherwise, why are we licensing him?
The only issue I think that when I looked at 1 and 2 was there was no prior disciplinary history. It's well within the board's purview to impose. We can change the recommendation to send in a consent order with a civil penalty of some amount.
If there's no prior disciplinary, does that mean there's no prior complaints?
Right.
Could there have been a complaint and we're not aware of it because it was passed on or something?
I doubt it.
Okay, so if they had a complaint, it'll show up that they already had one against them.
Correct.
Okay.
I'd recommend that we send a consent order with a $250 fine on both the 1 and 2.
Okay.
I agree with that. I was going to go a little higher, but, you know.
What has the board done in the past? I mean, I can remember walking out of here and having $3,000-4,000 in fines going out, you know. But then our new recommendations are we don't impose, or suggested recommendations, we don't impose any fines, and that's not the right word, but whatever it is. Civil penalty until their second violation. I mean, that's what's being recommended here.
And there's no requirement that there be you get a freebie.
Just in general, I feel like the last couple of meetings, we've had like lesser penalties than we have prior to the last couple of meetings, and that sort of bothers me a little bit. I feel like if they've got a license, they ought to want to keep their license. I mean, if the Board of Professional Responsibility sent me a letter and I didn't respond, my license gets suspended. So I just feel like we should be imposing fines or civil penalties regardless of whether they've had disciplinary history or not.
I double down on that with an out-of-state. I mean, if you're in state and you have a license, it's your business. You're here. You've got an office. You're paying attention to it. But if you're an out-of-state licensee, you know, what do you care about Tennessee? You know, you might be in California and you have a Tennessee license incidentally. I think if they're going to collect in our state and bother our citizens, they need to be aware they got to follow the rules. And 250, you know, that's...
Well, it's minimum.
Yeah, that's the minimum. I mean, or a letter of warning is way too minimum on not responding. It's kind of like the baseline. You got to respond.
What if we do 250 on the first one and 500 on the second one?
Differentiation.
You mean that on the second failure to respond?
No, I'm talking about number
Number
two
two.
on here because they're out of state. The first one is well, I'm sorry, never mind. I was wrong.
Yeah. I'm not sure we should treat in-state licensees any different than out-of-state licensees. They both have our license. They both read the rules. They pay the cost to do business. And those licenses that do pay attention to the rules are being discriminated against because we're not imposing the rules that they have to follow. Does that make sense?
Yes.
The question is a $250 fine, and Steve mentioned, and I call it a fine, I'm sorry. Steve mentioned that it should be more.
Well, I didn't really pick up much on the first one. My feeling was pretty strong on the second one. I don't see where the first one says it's an out-of-state.
The first one is a Tennessee licensee.
Oh, okay, that's
Yeah.
why. Yeah.
move that we impose a penalty of $250 along with a, what do you call it?
Wanting to step up.
That'd be part of a consent order.
A consent order, yeah.
Second. 250 on number one.
And $250 on number two.
I can live with that, but I'd rather go 500 on number two.
Why? Well, I mean, what's the difference in two and one?
Well-
in your mind?
Out of state, I think in number two, they ignored two things. They've ignored us twice. And a little more bothered by out of state not responding than in state not responding. I think state, you should be fined something. It's the consent order that should, to me, that's the most important for in state. There's not a good reason for balance. It's just a personal feeling. So that's why I'm backing off on suggesting 500. I don't have a reason.
The chairman can't make a motion, so if somebody will make a motion, we can move on.
I move that we impose a $250 civil penalty along with a consent order on item 1 on the legal report.
Let's throw item 2 in there as well.
Okay, and item 2.
Second.
All in favor of the motion, say aye.
Aye.
Okay.
Generally, if I could make a general comment, a 250 fine is not outrageous if they violated our rules and different levels. Not responding is kind of a big no-no to me. You've got to respond if you have a complaint. To me, that's kind of ground level that it ought to be a consent with at least 250 on a not respond. I don't know if that's what we have in our standard thing, but you know, where we're going to go look at the consent. But we'll wait till we get there. That's just my personal opinion.
I agree.
I agree. And worse than that is collecting without a license.
Oh yeah, that's a biggie.
A question that I have on number 3 is, it says in the last sentence on page 2, there's a statutory obligation to provide a debtor with such an itemized list if requested. Is that true? Is there a statutory
There
obligation?
is. It's buried in the statute, but it is there. If they request it, it's to be provided.
Itemized list.
That's what the statute provides, yes. I don't necessarily itemize, but it is a list of what has been paid and what's outstanding.
That's just a statement of account.
Right.
Yes, a statement of account.
So maybe going itemized might be a bit of a stretch.
Yeah, I think it is. I think the Fair Debt Collection Practices Act requires that a statement be sent upon request. I don't know that it says an itemized statement, which is difficult for a lot of people.
An agency typically doesn't get the itemization. It just gets, here's the person, here's what you're filed.
But the first notice, the required notice says that they have 30 days to request proof of the debt. And but it doesn't specifically say an itemized proof of the debt. It just says a proof of the debt, which, in my opinion, the hospital writes a letter and says, this Billy Bob still owes $280. It's not an itemized list, but as far as the agency is concerned, that's proof of the debt. If it's on the hospital letterhead, it is.
Hospital for an itemized bill?
No, itemized doesn't come into it. I mean, I think we're reading the word itemized into the statute, and it's not there. Comment. I think proof of the debt is what the agency determines is proof of the debt. And if the hospital says he owes $280 and I'm going to put it on my letterhead, then that is proof of the debt, as far as the agency is concerned.
I think the FDCPA, and obviously I don't have it in front of me, but I believe it speaks in terms of verification of the debt. And that's going to take some different forms. You can still have a valid indebtedness even though the promissory note no longer exists. It may have been lost or destroyed. So verification of the debt could take different forms. It could be a copy of a promissory note. Credit card application. A lot of times those things are done electronically now, so verification of the debt could take a different form. Now, as far as what our statute and the TCA says, whether it has the word itemized in it or not, learned counsel there as to that one.
Well, and the reason that I didn't, otherwise I would have plugged it into the report, because in this case, we're closing it anyway. But I did run across in looking at this, a statutory duty to provide, and again, whether or not itemized is in it, I don't know at the moment, but to provide some sort of accounting. Whether or not it needs to be line by line is what I'm not certain.
Payment history is an accounting of it, whereas an itemized statement is all the procedures that were done, in the example of a hospital. I'm not sure that you could do that given HIPAA, even though the agency should have a HIPAA release with the hospital, but to send it out without an itemized of what happened is very different than saying, here's payment history. I don't think you're, I don't know, but I don't think you're going to be in HIPAA problems with that, because the debt's already acknowledged to the person, and it's a medical debt. But
I don't think for the purpose of number 3 it really does matter, because we're going to close it anyway. But I just wanted to clear my mind in understanding that we're not going to impose fines or consent orders on an agency that doesn't send an itemized statement with a request for an itemized statement. I think the statute says proof of the debt or so forth. I'm not sure that we have to send itemized.
that's under the validation, but once it's been validated, once you're past the 30 days and the debt's validated, do you come back and say, now show me itemized? You've already validated the debt after 30 days.
I don't think you have to after 30 days.
I
I
agree
think,
with
well,
you.
let's go to, we'll bring our proof to court. I mean, the agency can take that stand if they want. Now, if they want to patronize and placate their client, they better continue to send statements like that, because it's rude, if nothing else. But statute-wise, after 30 days, you don't have to send them anything. Number 4.
I think the fine
Sorry.
should be bigger.
Beg your pardon?
I think the civil penalty should be bigger.
I agree.
We're talking about number 4 now.
Yes.
We've finished number 3.
We're on number
Okay.
4. Yeah, there's a fail to respond and no license, at least $500, and no license really bothers me. Like I said before, the agencies that are licensed, and I used to be one, Steve is one now, very difficult to keep this license.
Yeah.
And you guys happy?
Especially given the volume level of complaints that come in these days. I agree, it should be higher.
I move that we impose a $500 fine or a $500 civil penalty on number 4.
Second.
Motion's been made and seconded. We increase the civil penalty to $500 on number 4. All in favor?
Aye.
Hey, what about the fact that they're not licensed in Tennessee?
Well, that's the unauthorized, that's really, to be honest, the only thing we can hit them for is the unauthorized or the unlicensed activity. The failure to respond only applies to a Tennessee licensee, but we can But $500 is still well within the range for an unlicensed collection act. So I think that's a.
Thank you.
So we can't impose, I see what you're saying, we can't impose a fine, somebody that's not licensed.
Correct.
Got it. I think 5 is fine. Number 9, once again, a failure to respond, an active license in Tennessee. I think it should be $250.
I agree. I move that we impose a $250 civil penalty on number 9.
Second.
Motion's been made and seconded. All in favor, say aye.
Aye.
On number 12,
We're getting the same ones.
I beg your pardon?
I have the same. I have the same ones marked that you.
Are you
have.
copycatting me?
No. But number 12 bothers me too.
Yeah.
Why are we closing it? Of course, this goes back to the itemized statements discussion. We don't know if this was in the 30 days. Or do we know if this 30 days where you can dispute?
And once again, the respondent says they provided the complainant with a statement. The complainant, however, says the summary was a one-line summary and would not be what a hospital would submit to an insurance carrier. I don't know that the agency is required to send that to the complainant. Maybe I'm wrong, but I think of one line, this is what you owe, and if it's on the radiologist letterhead, then that's it. If he wants to go to court and question the amount, then that would be time to do that.
Do we know if this was in the first 30 days?
We can take a look.
Because if it was in the first 30 days, I think they got room to ask for detailed information or what is this debt really? It's just not a radiologist saying you owe it to me.
Well, I'm not sure they do, Steve. I don't remember exactly what the 30-day validation notice says, but
You guys got to prove the debt if they ask you to prove it.
the radiologist says, Steve Harb, you owe me $280. In my opinion, that's proof that the agency has done its job by providing proof of the debt. If that doesn't satisfy the complainant, then the complainant can go to court and request that and require that. I don't think it's incumbent on the agency to provide an itemized statement, and that's the word that I'm hooking up on, itemized.
I think you all asked a question about what the FDCPA says about the validation of the debt. It says the agency should send the consumer a written notice containing the amount of the debt, the name of the creditor to whom the debt is owed, a statement that unless the consumer within 30 days of receipt of the notice disputes the validity of the debt or any portion thereof, that the debt will be assumed to be valid by the debt collector, a statement that if the consumer notifies the debt collector in writing within the 30-day period that the debt or any portion thereof is disputed, the debt collector will obtain verification of the debt or a copy of a judgment against the consumer, and a copy of such verification or judgment will be mailed to the consumer by the debt collector, and a statement that upon consumer's written request within the 30-day period, the debt collector will provide the consumer with the name and address of the original creditor if different from the current creditor.
And to answer the other question about what the complainant actually received, the complainant, essentially the complainant submitted a rebuttal. So we had the complaint, and then the respondent, the licensee responded, and now the complainant's going to respond again. And they said, and I'm not obviously going to use any names here, everything's going to remain anonymous, but yes, in a broad sense, the response from the licensee is accurate. What was sent to me was a one-line summary statement on licensee letterhead. And then, of course, then they sort of then have it's not a more detailed invoice. So they admit that it was they got a one-line summary on the letterhead from the licensee.
Statement validating the debt.
Correct.
I think as long as it contains those things.
Contains those things she just mentioned, right, and it
The,
did.
the original date and the date the services and so forth. If that came on one line, if all that information came on one line, would it satisfy the requirement? So an itemized list, you know, a shot here, a aspirin here, a whatever. That, and in my opinion, that's what I get when I go to the hospital. That's not required.
No, it's not.
Okay. Yeah, I'd close 12. I'm just trying to work out this itemized statement word that we seem to be using too much. Debtors don't have a right to an itemized statement, not from the collection agency. Now they
Right.
may with their
creditor.
insurance company or with the provider, but the collection agency doesn't have to send it down. Number 13, interest can only be charged if it's contracted for. Do we know whether or not the agreement that the patient signed with the dentist, I think it's a dentist,
It is.
that the patient signed an agreement agreeing to pay interest or collection costs or what have you?
I don't believe that we do, but we can look at we've got our laptop that links us back into the original complaint file. I'll take a look. I don't believe that I remember seeing like a patient-doctor contract or
Court costs are statutory charge, but in my way of thinking, you can't charge attorney fees or interest unless the consumer
contract.
contracts for it.
right. No, it looks like that they only provided just they actually have an itemization in this particular instance of showing all of the work and what dates and whatnot, but no consumer, the patient and the doctor that I can see.
Would it be within our authority to ask the agency to provide us with a copy of the contract that he has?
We could certainly, and with this complaint, we could table it until the next meeting. I don't know what the status. If it would go over or not. That's more of an issue, though. But we could contact the consumer or the complainant. The consumer or the licensee, and have them provide us, if they can, with a copy of that. Complainant to sign some sort of HIPAA release to give that to us if they wanted to, but we could explore.
There's another one. There's another one in here like that, and I don't know if it's the same.
It's number 14.
Is it number 14? Is it the same thing? I don't know if it's the same agency or dentist, and I don't need to know. But I think it's something that we need to be aware of, because there's a lot of times when I had my agency, my client would call me up, "Oh, by gosh, I want interest." Well, you can't get interest unless you contract for it, and I'd help them write their contract even for future clients.
But we could table those two, 13 and 14, to see if we could find a patient-doctor
Okay.
agreement with any kind of language
Yes.
reflecting
Yeah.
accrual of interest. And
Right.
doctor being entitled to that if it went into collections.
I think we could ask the complainant, but he probably doesn't have a copy of what he signed. I think we'd have to go to the agency and tell the agency we want a copy of
Go
what
to the doctor.
Yeah.
When we send letters of instruction, do they just say, make sure you abide by the act, or
Effectively,
what?
right.
Do they have specific parts of the act that we're concerned about in the letter?
Well, in this case, if we did that, it would be just the Fair Debt Collections Practices Act.
Okay.
Unless the board decides to highlight a certain section, you can definitely put whatever statute or rule in there that you would see fit.
So I kind of feel like rather than having everybody jump through all these hoops, that if we send them a letter of instruction relating to the specifics of, they can only collect interest if there was a contract, and that they need to make sure they have a contract before they start trying to collect interest. I kind of feel like that's good enough, and then we don't have to spend all this time and energy
And revisit it later.
and revisit, but that's my opinion.
That's a great idea, Angela. And if we'll just do that, then letter of warning based on the whatever statute or law or it is that you have to have a contract to charge interest, and then just leave it in their court. Good point.
And then if they still collect on it and they don't have a contract, then there's things that can be done.
Just for clarity, would that be for number 13 and number 14?
I think definitely number 13. On number 14, I have a question. Why are we sending a letter of warning on 14, but only a letter of instruction on 13?
That could have just been a typo.
Are they the same thing?
Yes.
Okay.
Same company.
That's fine. No, I meant like, do y'all distinguish between a letter of instruction and a letter of warning?
In effect, yes, because neither one is really considered to be discipline like signing a consent order would be. It stays in the file.
I know. Are you interchanging the words warning and instruction to basically mean the same thing?
Yes.
Okay, that's just all I wanted to know. Then it's fine with me to do the letter, but I think they need to be two separate, obviously, even though it's the same agency, two separate letters.
For my purpose, whenever I got a letter of warning, it meant more to me than a letter of instruction. So I like the word warning.
I agree. Okay, I move that we send a letter of warning on items 13 and 14 on today's legal report, and include make sure that they know that they have to have a contract in order to collect interest.
Motion been made. Is there a second?
Second.
Motion's made and seconded. All in favor say aye.
Aye.
Once again, on number 15, we have in any event, the complainant is requesting some proof before paying the amount of money.
This is probably going to be the second time I've asked this ignorant question, but it says it's a small business. Does the FDCPA, do our rules apply to other than consumer? If they're collecting from a business,
Yes, but anybody that collects from a business, if all they do is collect business accounts, they have to be licensed. That right?
Yes.
Number 17, I don't necessarily have a particular problem with it. I had a collection agency that was using some of my services once, and they quit paying me. They owed me several $1,000s, and they changed their name. They changed their corporate. They went out of business, but they were the same company. They just made a hoo-ha of it, and they were out of state, and I didn't want to pursue it any further. But I think we need to be aware that companies go out of business, they don't pay their clients, they don't pay their creditors, they do otherwise bad things, and then they say, oh, let's open another agency, we'll just call it, instead of 123, we'll call it 321. And I just want to make sure we're right. And at the bottom it says, who has a similar name. That's what that agency did to me. Number 19. I think our Tennessee statutes prohibit suing payday loans. You can't sue somebody for a payday loan. And if they're threatening to sue somebody that they can't sue, that's a serious violation. Got that, lawyers? Can't sue a payday loan.
I don't know.
I have no idea.
I used to have a payday loans company, so you can't sue them. There's some question of whether you can even put it on a credit file. The Payday Lending Act, the act that provides for payday loans, cash check loans.
Check loans.
Yeah.
It says you can't be sued.
You can't take them to court.
Well, the respondent says they haven't attempted to sue the complainant.
Oh, but they send it to a collections law firm. I think by sending it to a law firm would leave the impression that you're intending to sue.
I think it
Maybe
says, the new information says it's a collection service and not a law firm.
And the last paragraph says that eventually the account was sent to a collections law firm.
Yeah, but on the next page, there's new information.
I think the issue that this is one that had been left over from a previous legal report. The issue is going to be that, assuming that if there was some statement by the complainant saying that they threatened to sue me over the phone, unless we have the actual, they provide us with a tape recording of the phone call, it's rather difficult to prove that.
Said she said, I know. If you would you look up that payday loan statute just for our purposes for the next meeting? It's not so that important, and to see what that it may say that you can sue them, but you can't charge them court costs, or you can't charge attorney fees, or I may. When I had my company, I never sued anybody because I understood by the statute I couldn't. Anything else, anybody?
On number 19? Or any of them? Are you talking about number 19 or any of the rest?
Any others on the report? I think we've satisfied 19, have we?
Yes.
Okay. Any other questions or corrections to any of the other?
Just on number 21, so the previous recommendation was to send a consent order with a civil penalty of $1,000, and then the new recommendation says sustain the previous decision to impose a $500 civil penalty. So I don't know if it was $1,000 to begin with, and now we're changing it to $500, or if it was $500 to begin with.
It was $1,000 to begin with. We represented it. The board had voted to reduce it to $500,
Oh.
and then an attorney got involved because up until that point, no one had ever popped up on the other side to say anything other than talking to one of the collectors at the location. And I agreed that I would, pitch this back to you all to say, okay, I understand what your argument is, but our view is that if you attempt to collect a debt, it doesn't matter whether you're physically here or not. And they did. I mean, there's no question. They sent collection notices. They made phone calls.
So the lawyer's just trying to bully us around?
Well, he's trying to, being that he's now involved, he wants to, I guess, earn some degree of his keep. So,
Can't bully a bunch of lawyers.
Just like a lawyer.
Okay, then I don't have any issue with it. I move that we, other than the ones that we've already talked about, I move that we accept the recommendation of our legal counsel for all of the other items on the legal report.
Motion's been made. Is there a second?
Second.
All in favor of the motion, say aye.
Aye.
Agreed citation schedule.
If we can just, if we can move to legislative updates and then work our way down from there, would that be all right?
Beg your pardon?
If we can, can we cover legislative updates next and then just
Okay.
hit that one last?
I'm sorry. Yeah, go ahead.
Okay.
Legislative updates.
So the only legislation that passed that's specific to the board was the sunset that extended the board for 6 years through June of 2024. There was the passage of the Fresh Start Act, and what that law requires is that when reviewing an application, if the board decides to deny an application for a criminal conviction on that person's record, there are certain factors that they have to discuss and go through prior to denying that application. So essentially, the conviction has to directly relate to the profession they're trying to become licensed in, and we just have to have that discussion on the record, and we have to give them notice that this is why we're denying it. So I think that's the only other piece of legislation that would affect the board. I'm not sure exactly how application process is here. Do we bring individuals to the board, Glenn?
Oh, yeah. Yeah, we have to. There's a administrative process where you have to put it in writing, explaining what it is that you're alleging and your reason for wanting to consider denying that application. And then, like with other applications, then those would have to be also approved by the board. That's at some point you'd have to.
If that comes before you and you see a conviction on their record that you would deny it for, we just have to make sure we go through a list of factors that's in the statute, making the connection between the license they're trying to receive and the conviction that you're using to deny them.
And being the industry experts, that's why it would make sense for us to bring those objections to you, because then you could make that determination. Yes, that would directly align with a conflict of interest of moral turpitude or whatever to this.
But that's something that is handled administratively without coming to the board. We don't see each license anymore. We used to see every one of them that came in here, but, okay.
It's matters of dispute where that could weigh in.
Right.
Do we need a motion?
No, that was just an update for you all.
Rule 0320-05.01, parenthesis 5, discussion.
All right, you got
all
that. There's if you look on your desk, there's a proposed rules filing form. As you know, there was some rules that were filed that were effective in June 5th. Basically to write back in those FDCPA kind of modeled after that protections. And if you go to the definitions, which is the first, I believe it's the second page. Yeah, you've got your, of course, your contents, and then the first page, definitions of debt. It's the last line that we're interested in, number 5 there. Under under definitions, number 5, it says the term includes any debt, whether defaulted or not. That or not was a concern, only because it could potentially be construed as first-party collections or people that own the debt, it's defaulted or not. But yeah, that's kind of a reach for one, because there is the exemptions that close that sort of if there's any misunderstanding. If somebody was to come to us with a misunderstanding in regards to that, we would point them to the exemptions, and the exemptions under A 62-20-103, A9B, nothing contained within this chapter shall be construed to require an individual or business entity that collects only the individuals or its own unpaid account to submit to licensure or regulation by the Collection Service Board. So, but we just wanted to at least bring that to the attention of the board, since there was some concern. If you felt like there was some concern there that "or not" phrase could extend and create some sort of confusion, then of course we can eliminate that from the rules at some point as well. But that's of course.
There's
Yeah.
mortgage servicing companies, and there's a lot of people that do
Sure.
servicing of debt, but
They're not agencies.
they're not agencies. It's been a question in my mind for years.
So
But-
if the debt's not delinquent, it's fresh debt, and it can be serviced by anybody?
I don't think they have to have a collection license.
So that would kind of.
And I think that's what Glenn was getting at as far as that line being confusing. Like he said, if we got any questions about it, we would of course point them to those exemptions. But if you think that it's going to cause a greater confusion to the public, we can of course go back through and just do another quick rulemaking to take that sentence out of that definition.
I think it is confusing. Is that what's on the website? Is that sentence on the website?
Where the rules are posted, yes, sir. This is what it looks like when people look it up.
Just personally, and I'm not speaking for the board necessarily, but just personally, I think it is a little confusing to folks that want to get into the collection business, and they read that, and they want to service mortgage accounts, or what have you, and they read that, they would question.
So what I can do prior to the October meetings, I can prepare the documents to have just that one line deleted, and we will send it through the process and get that taken out.
Got to stay busy. That's why.
Wrote it in there to begin with. Where did it come from?
Prior attorney.
Oh, okay, thanks.
Are we on agreed citation now?
Sir, we are. We on your iPads there, if you were to take a look at that, you can go and pull that up. If you recall, we kind of gave you just a rough template, and there was some discussion as to what would be appropriate response to first, second, third offense. That's not here included, but at the last page in particular, we wanted language that would deal with. Let me see if I can find the exact words. Yeah, language added to the agreed citations regarding non-payment. So that highlighted portion that is the response to that request. So that was the only thing that we added or changed on our end. Now, as far as the first, second, third offense, after listening to the legal report, there may be some adjustments to that one to make sure that we're more in line with the will of the board on that one. I would allow Ms. Thomas to more to elaborate on that piece if you had any questions. But other than that, what we may do, I didn't get any edits that just stood out or that were in response to our first solicitation. So what we may do is it may be more productive just to go ahead and cut it up at the next meeting, just with some of the new edits that we added here from the first, second, third offense, and then just kind of as a mini work group, we'll just kind of see where it goes, and if we get to a really good place, then we can move on it then. But if not, then we can table it and bring it back as unfinished business.
What we're trying to do is centralized complaints. I guess that's a department that if they did this, we're going to fine them this and send a consent order. So that's what we're trying to do?
That's an option. It'd be just like a speeding ticket, that they just pay it out and then they can, then they don't have to, it doesn't have to make its way to the board. We just basically cite them for, if they agree that, yeah, I've done this, agreed citation, and they can just settle it, and it doesn't have to be handled through a disciplinary action council or whatever if they just, and so you're saving the legal expense on that report. Well, we've narrowed quite a bit with the two prongs, but we feel like we can go a little bit further and get that legal report down. Now, obviously, if they dispute it or whatever, then they'll have their day in court, before the board.
And the particular offenses that I listed at the last meeting were ones that when I look at them, I don't think that they necessarily require the subject matter knowledge that the board gives. So, for example, the attempting to communicate with a consumer at an inconvenient time, that's set by statute, so we can look at the facts as they come into us and determine if that's something that violates that statute, and then we can send a citation out for that. Now, if they say that they dispute that, that would then go on to Dennis for the legal report for the board to make that determination. But if they agree to that, yes, I did contact them at 10:45 at night. I'm going to pay whatever the civil penalty is or whatever the board decides that first violation would be. We can go ahead and process that, close it, and then the board doesn't have to see it. So that's where I was going with the few that I picked out. I know that the board wanted the opportunity to kind of look through and see if there's anything to add or take away from that, something that you wanted to maintain, that you all wanted to look at as a complaint versus an agreed citation.
I kind of like the legal report. I don't want to make more work than is necessary, and some of those things are obviously like the ones we close. They didn't do anything wrong, or complain about the hospital sending them a bill. We're not licensed. So those kind of things can obviously be handled with a letter or to the complainant. But if we got a licensed agency or an unlicensed agency that's otherwise violated our rules or the FDCPA rules, then I think we should read it.
And I don't want to confuse the board by saying we're doing away with the legal report. These are just specific violations that can be settled without having to come to the board. So if we got something, so we don't meet again until October. If this were in effect and we received something next month for attempting to communicate outside the agreed time, we could go ahead and process that and close it rather than having to wait till October to present that to you all to say that they need a letter of warning. So that's what I'm thinking, but we're not doing away with the legal report at all.
The first one on here, the first offense is a letter of warning, and then we go unlicensed activity. Well, gosh, unlicensed activity ought to at least have a $250 fine.
Absolutely, and that's what Glenn was mentioning.
Yeah.
Listening to
based on
you all discuss the legal report, we of course can adjust those violations and the offense amounts as the board sees fit.
That was both of our notes as we were listening to you, renting out the fees. So we were like, okay, we're going to have to adjust that citation schedule. So we can, and then that also provides some consistency as well, because we were talking about prior years, what we've done in the past, and then if we have an agreed citation schedule, we know what we've done because that's what the schedule tells us what we do typically.
I think I might be missing a page on my iPad. I have 3 pages on this agreed citation schedule. One is Exhibit A, then the agreed citation itself. Is there an actual schedule?
There is, and I sent that at the last meeting. It didn't make it to the iPad. I apologize for that, but I'll send you the completed version, so you'll get that as well.
Okay.
So we're not actually carving it up today, so it didn't make its way there, but we'll have the complete with the new adjustments on the schedule as well, and so you can take a look at that.
Okay.
Just maybe describe the kinds of offenses you would not consider, kinds of offenses that would only need a warning, as opposed to a
So when I was going through, what I was looking at was, I'll take out the unlicensed activity just based on the discussion today.
Yeah.
Attempting to communicate at an inconvenient time, communicating with the person other than the consumer, communicating with the consumer after receipt of written notification to cease communications, engaging in false or misleading representation, and failure to comply in providing notice of debt to consumer. And those were the ones that I put on the original schedule.
The false information bothers me.
Me too. Yeah, because that's kind of, you got to determine that based on the facts and circumstances. It's not you did it or you didn't do it.
So to come off the schedule or to adjust the amount? Would you? So I guess what I'm asking is, would you want to see all of those?
I'd rather
Yes.
see those. Yeah,
Okay.
I want to see those.
Okay.
It seems like it would have to be a very cut and dry thing. You did it or you didn't do it. You called them after 9 o'clock or 10 o'clock. You did it or
Right.
you didn't do it.
Okay.
But those are pretty straightforward.
I'm not sure how much information we need to give a consumer, but if he's been called at odd hours of the night, then that's a violation of the act, and it's $1,000 minimum fine plus attorney fees. And I don't know if we should take it upon to tell the consumer, the complainant, hey, you could call a lawyer, you could call Morgan and Morgan, and they'd get you $1,000, and we'd make that agency pay us. You know, I used to hate those calls, those letters, but I don't know if we do that or not. But just for us to send a letter of warning when we've got an agency out there that's calling people at odd hours of the night, that's bad stuff. And we may not want to fool with it, but I know Morgan and Morgan love it, or maybe somebody else.
Well, this looks like
It's a work in progress.
you guys are ahead of the class. That was our first working group already, right
I
there.
think
We just did it. But we're going to carve it down based on the comments made today, and if we're not going to force it. I mean, if it looks like it just isn't working, or we just got to, even if we just get a couple, that we think we can handle a bulk of a lot of these complaints, then that's great. Or we scrap the whole thing. That's fine too. But we'll bring it all to you at the next one, based on the comments here, and then we'll work from there.
Thank you, sir.
Yes, sir.
New business?
We do. We got the NACARA annual conference. As you recall, last year, Bart and I attended that. We brought back a report. Basically, it's the annual. It's the professional association for collection agencies and regulators. And we were in Seattle last year. This year, they're going to have it in Charleston. It's in October the 14th through 17th. From that, if you recall, we brought back updates regarding consolidation of similar license lines. We had that discussion, introducing the NMLS system as a modern platform for multi-line and multi-state licensing and coordination. We discussed raising the bond limit. That came out of that discussion. I even heard a little bit early on about statute of limitations. They had that discussion there as well about extending that. Now, that's beyond our purview. That's something that would happen at legislators. But those are the type of discussions that they have there. They have regulators roundtable where they're discussing methods and processes, coordination. There's also the NACARA protocol, or I forget what it's called. Let me see if I can find it here. Yeah, the nationwide protocol agreement that's coming out of NACARA as well. We're looking at signing that, where we may not have a formal cooperative relationship with them, but this kind of formalizes that. All the member states that are part of NACARA, those regulatory bodies, they send us updates, and we have a membership as this state does with that body. But now we can formalize that cooperative relationship more closely. So the executive management's looking at signing that. We may not be in MLS yet, but that's one kind of workaround to more formalize that relationship. But those are the type of things that we discussed then. If there was, if the people wanted to reconsider or consider for the chairman to attend this one, or another member of the board would like to attend as well, that would be your within your power to make that. Discuss it on the front side. Any questions about that in particular? They didn't give us a real heavy agenda yet, so I don't have anything to put on here, but we just know it's coming. In October, we'll already be here. Our next meeting is the 10th, and then 4 days later, they're going to have their event. So obviously, that wouldn't give us enough lead time to work through all the travel memos and all that sort of thing. So we're having that discussion today.
Last year, Glenn and I went to it. Very, very informative. We missed several years of it. I used to go all the time, and I think it keeps us in tune with what's going on in the rest of the country. And you got bad operators in Colorado, and all of a sudden they want to start operating here. That this organization helps solidify those problem areas that we have. Does the board need to make a recommendation?
There would just have to be a motion or a recommendation for how many and who they would want to go, and then, of course, a vote in that regard. But one of the things, too, he was talking about relationships. The Maryland Assistant Commissioner, he's also the vice, I believe he's the vice president of NACARA. When we were having those discussions about NMLS, we fomented a relationship with him, and so he was the one that was helping us kind of wrap our minds about how that would work its way through our license lines as well, because they've combined all of their license lines on the NMLS platform under one regulatory body. So when we were discussing that as potential, it was that relationship that was helping. We were leveraging that relationship and their past practices and experiences as well. So those are the type of things that those professional bodies, and as you know, many of you are in professional what the benefits of those are. So no need to belabor that, but there would have to be a motion in that regard if that was the will of the board.
I think the board could entertain a motion that one member and Glenn be present at the meeting.
So moved.
Second.
Then we'll just have to decide on who then for the discussion. Yeah. So that looks like we got two then.
I have a trial during that date, so I can't go.
I'm not the right person to go. I think we need continuity. Josh, if that's something you're interested in learning about, it'd be great.
I'll be taking 2 young children to Disney World that day.
So I guess the chairman has to go.
I went to Disney World and I told my grandson that I know I'm going to heaven now. Why is that, Granddaddy? Well, because I just got through with hell. Bless your heart.
There's a send off for you. Isn't there?
Okay, is that a motion that Glenn and I be recommended to go to the?
So moved.
Second.
All right, all in favor?
All in favor?
Aye.
All right. And then just one just quick little thing I want to throw in there in the new business. I was going to do that to you. It just occurred to me this morning. There was some information requested at the last meeting, so I'll make sure you get that information. It was how many do we have in collections? If you recall, we how many folks do we, that don't pay their agreed citations or don't respond to the orders that they've signed or have been levied against them? How many do? Because we have our own collection days. How many of those do we have in those bodies? Right now, we have 1 in collections, and then we have 4 that have been authorized, or they've been moved towards formal charges authorized, meaning that internally they would have to have a formal hearing, and then whatever the decision of the board in that formal hearing, once agreed upon, if not paid, then at that point, then it goes to collections. So you can see there's a lot of layers. It's not real easy to get into collections.
Goes to collections as opposed to pulling their license?
This particular company is no longer licensed. This is a case from, I want to say, 2008. It was turned over to the AG's office to collect the money on behalf of the Collection Services Board.
We don't send anybody to collections as a licensed agency. We pull their license first, I assume.
Well, a formal hearing.
So we would have the formal hearing, and if a penalty is assessed at that hearing and they don't pay it, our typical policy is to send that to collections. However, I think the board's discussion was you wanted to pull the license. That would have to be included in that formal hearing order, that failure to pay results in the revocation of your license. So that's something that wouldn't be decided until we got the formal hearing.
Question came up because, and on the report today, it said that last fiscal year we've collected $3,000 in fines, and we'll come out of here with over $3,000 in a meeting. And what's happening to that money? Whether either they're not signing the consent order or they're signing the consent order and not sending in the money. The collection agency, and you're talking about 2008. Once again, statute of limitations. I don't know I don't know what's going to happen with that. But when we impose a $250 fine for failure to respond, I just want to make sure that money's coming in here.
Right, and so that's what would happen. Dennis will send out that consent order to say they can settle this for $250, or they can go forward with the formal hearing. They may get to a formal hearing, and the penalty is increased to, I think the maximum is $2,000. We get either an order from them. They would agree to that prior to the hearing, or a judge would sign that order saying that we have the right to get the $2,000. If they don't pay it, then it goes through the collections process.
So if they're not coming for a formal hearing, they've signed the consent order and sent us a check?
If they sign the consent order, it would not come to you for a formal hearing. If they've signed the consent order, it would go right to collections because we don't have to have the hearing because they've already signed and agreed to pay.
I don't know. I kind of feel like if they don't pay the money when they sign the consent order, that their license should be revoked, but.
And what I'm saying to that point is that has to be included in that consent order that they're signing. That's language that would have to be in that consent order.
And I think we should put that in.
That's a conversation.
I mean, again, it comes back to all these other boards. We're all, those of us that are lawyers, we have to be licensed by the Board of Professional Responsibility. If we don't respond to their letter, our license gets suspended. So I don't know why we're letting people continue to do all of this stuff and just ignore us.
Right. And so that's what I'm saying. So what Dennis can put in his consent order is language that says failure to pay this results in suspension or revocation or whatever the board's desire is.
Yes, I agree. I think
It
that's.
seems like that's what the
Revocation.
consent order is anyways, when you agree to sign this and consent not to do this anymore if you pay $250.
Because I don't draft the consent orders for this board, I'll defer to Dennis as to what they actually say.
For these, and I'd have to go actually pull one from like my desk or from my H drive. Let's just take the example of a $250 civil penalty that's been recommended or voted upon by the board, and they don't. And well, first of all, they agree to a certain set of facts. They agree that they committed whatever we say that they committed that stems from the complainant's complaint, and then they send in the money along with the signed consent order. Like Ashley was saying, if they send the consent order with no money, then we can just simply send it to collections. But if they don't send the money, can we just simply revoke the license? And some we have, I know in other boards, we used to have that just as automatic language, that if you don't send us the money, then you're consenting by signing this to your license being revoked.
And I think that's what the board is asking that we include in our consent
Yeah.
orders from here on out.
If they don't send the money, they haven't consented. I mean.
Well, I guess
it's-
they've
it's not-
consented to
It's not
the
a complete
facts.
transaction. Okay, if they
Practically,
consent.
though, you're right. I mean, there's no benefit, right?
Yeah, it's not two parts, it's one thing. You consent and send the money. That's the entire thing. I mean, to weasel out of the money when you said you've done something wrong is just, they very quickly, in my opinion.
I guess my point is that if we don't have any teeth behind whatever it is that we're doing, then why are we even doing it?
Precisely.
I mean, how many people sign the order and don't send the money? Does that happen very often?
No, and that's what Glenn was bringing up. We only have the one in collections. So anytime that we've sent out a consent order, if you don't hear about it again, it's because they've paid.
Oh, okay.
Well, today, and I'm not sure whether it was $1,000 or $1,250, but today we have agreed to collect $1,250, and all last year we only collected $3,000. And I remember a day that we came in here and had a meeting, and we had $3,000 in a day.
I was really surprised by that report that we only had $3,000 for the whole year last year.
And now we only have one in collection, and it's from 2008. If this was my business, then I would make sure that the people that we are fining, and statutorily we have a right to do that, and we're fining and they're not paying it,
Art, it is your business.
well,
What we're doing here, they pay us every month. I can't
$50.
understand it. Yeah. Lord, they got us, man. They pay us.
Yeah, I think that's fine. To have a motion to include that language in every outgoing consent order from here on out.
I move that we include language in every outgoing consent order from here on out that if they do not pay the fine or the civil penalty that we have imposed, that their license is suspended on what is it, 30 days that they have to do it?
Generally, we put 30 days as a suspense time to act on the
Okay,
consent order.
then if we do not receive their payment within 30 days, then their license is suspended or revoked. What language do we need?
Suspension implies that at some point we can lift that. Revocation is actually taking their license.
Well, let's just suspend it then.
I don't think we have a suspended license. And then, is there a question about that license is, what do you call it when you start trying to take people's property? and it's their property,
Process.
a due process. Is that consent order?
Yes, it is, because they've been given notice of that, and they can choose to sign it or not. They could, if they choose to not sign it, they can have a formal hearing.
Well, that is due process. All right. My only,
You should just revoke it. If they don't ask for a hearing, suspending it, what does that mean? They have to close their shop until they pay it? Well, they're not going to do that. And then if they do another problem while it's in suspension, are they an unlicensed agency at that point?
They're working on a suspended license at that point, which is
Well-
a separate violation.
It's separate from being not licensed.
Right.
What does it mean to be suspended? What activities are curtailed?
All of them, because you're working without a license, you're working without a valid license at that point. But when you say you're going to suspend somebody, you're suspending it until they pay the civil penalty, you're suspending it for 6 months, you're suspending it for a year, versus revocation, they would need to completely reapply to become a collection agency.
so if we use the word suspend, they don't send in the money or the consent order, then in 6 months, they say, oh, I'm going to sign this consent order and send in the money, then their license would be
We would lift the
reinstated.
suspension, right.
Okay. Is there something in our statute that provides for suspension of license?
That would just be a disciplinary action by the board to suspend the license.
Oh,
And again, this is all on a consent order. So if they don't sign it, we cannot just automatically revoke their license. If they don't sign that consent order, we'd still have to go through a formal hearing to take that right that Mr. Howard was talking about as far as due process. So it's only effective if they sign the consent order.
Well, I guess my point is that goes back to that report that said we only collected $3,000 all of last year, and I know that we find a lot more people than that. So that's my concern. And then I guess the concern would be if people stop signing the consent orders because it has this language and we're having a bunch of formal hearings, then at that point we can revisit it. But I think it needs to go in there immediately, and even on these consent orders that we're sending from today's hearing.
sure. And I'd kind of like to see an accounting of last year's fines, and this one. I don't need anybody's name, but where's the money? Because it's not showing up on that report. That's what I said. If it was my business, and that's my accounts receivable, I'm going to want to know who's paying and who's not.
You'd need to be obviously very clear to say, if you don't sign it and send the money, if you don't do both, your license is suspended. And suspension means you've got to cease and desist from all collection activities. I think we need to tell them what suspension is. It's just, it's not revocation, because if we say revocation, then it's just pulled and they can't be. But do you mind saying suspension means you must cease and desist from all collection activities?
I'm fine with that.
Let's let them know what it is if they're not going to sign it, or you can request a formal hearing. We're good with either one, but you better do it, and you better do it soon. Pick.
I think you'll see our money go up.
Just remember, all this is contingent again on them signing the consent order.
Correct.
That's fine. And then if we get a bunch of people that request formal hearings, then we can always revisit this, right?
It looks like we have a motion on the floor. Ms. Hoover still has a motion. Do we have a second to that regard?
So let me amend let me strike my previous motion and say it this way. I move that all consent orders from beginning with the ones that we're sending from today's meeting forward include language that if the payment is not made of the civil penalty along with the signing of the consent order if they sign the consent order and the payment is not made within 30 days, then their license is suspended, and there shall be some language regarding that suspension means cease and desisting from all collection activities until the suspension is lifted.
Or a formal hearing is held.
Or a formal hearing.
What if they do not sign the consent order?
Then they get a formal hearing.
And all right. Failure to sign the consent order will result in a formal hearing
Yes.
to revoke your license.
You can elect to have a formal hearing. Let them elect it. I'm not signing it. I want a formal hearing.
Right.
They should
Both of those-
respond.
both of those are options,
They have to
absolutely.
respond with one or two of
Right.
them.
Both of those are options. They can contact us on day 2 and say, I want a hearing, so then we're not waiting on the consent order, or the 30 days can elapse and we'll move forward with the formal hearing part. And that's why his recommendations always say formal charges authorized, so that we don't have to come back to the board to get permission to start the formal hearing.
Second.
All in favor, say aye.
Aye.
Good motion, thank you. Any other business to come before the board? Not, we'll stand adjourned. Glenn, you'll contact the commissioner, the powers that be about the trip? Yes, sir. Okay. Anybody want me to bring them back oysters?
God, no.